Hello guys, welcome back to my channel Rahul Study. In this video, we talk about a case which is related to strict liability of law of crime. This case citation said State of Maharashtra versus Mayor Hans George 1965 first SCR 123 All India registered 1965 Supreme Court page number 70 720-22. In this case, we will clarify about the strict liability. It is term of law of crime which gives us without mens rea we can charged if the country gets disturbance in economic stability. The mayor Hans George was charged under the Section 8 of Foreign Exchange Regulation Act, that is FERA Act 1947, which was against person transporting prohibited articles through India. So, Justice K. Subbarao was the judge for this case, and he gave judgment regarding this case. So I am going to start this judgment. So please open the case material of law of crime provided by Delhi University for the 3 years LLB program. You can also get this PDF from my Telegram channel, namely Rahul Prudent Study. You can easily search on Telegram, search inbox. So I am going to read this case. For this case, we will try to understand the meaning of strict liability, and you can say exception of crime. Crime constitute by the major element actus reus plus mens rea is equal to law of crime. So let's start the guys of the fact with the fact of this case, State of Maharashtra versus Mayor Hans George. Justice K. Subbarao, I regret my inability to agree. This appeal raises the question of the scope of the ban imposed by central government and the Central Board of Revenue in the exercise of the powers conferred under section on them under section of Foreign Exchange Regulation Act 1947 against person transporting prohibited articles through India. For better understanding and details about FERA Act, you can visit FERA Act 1947 on Google. Okay. In exercise of powers conferred under section 8 of Act, that is FERA Act, the Government of India issued on 25th August 1948 a notification that gold and gold articles, among others, should not be brought into India or sent to India except with the general or special permission of the Reserve Bank of India. On the same date, Reserve Bank of India issued a notification giving a general permission for bringing or sending any such gold provided it was on through transit to a place outside India. On November 24, 1962, the Reserve Bank of India published a notification dated November 8, 1962 in supersession of its early notification, placing further restriction on the transit of such gold and a place outside the territory of India, one of them being that such gold should be declared in the manifest for transit in the same bottom cargo or transshipment cargo. The respondent left Zurich The respondent, that is Mayor Hans George, left Zurich. This is the fact, guys. Just listen. The respondent left Zurich by a Swiss aeroplane on November 27, 1962, which touched Santa Cruz Airport at 6 a.m. on the next day. The customs officer, on the basis of previous information, searched for the respondent and found him sitting in the plane. On a search of the person, the respondent, it was found that he had put on a jacket containing 28 compartments, and 19 of them he was carrying gold slabs weighing approximately 34 kilograms. It was also found that the respondent was a passenger bound for Manila. The other facts are not necessary for this appeal. Till 24th November 1962, there was a general permission for a person to bring or send gold into India if it was on through transit to a place outside the territory of India. But from that date, it could not be so done except on the condition that it was declared in the manifest for transit as same bottom cargo or transshipment cargo. When the respondent boarded the Swiss plane at the Zurich on 27th November 1962, he could not have had knowledge of the fact that the said condition had been imposed on the general permission given by the earlier notification. The gold was carried on the person of the respondent, and he was only sitting in the plane after it touched the Santa Cruz airport. The respondent was prosecuted for importing gold in India under section clause 1 of the act, that is FERA Act, read with section 23rd subsection 1 capital A thereof, and under section 167 clause 8 clause I of C Custom Act. The the learned presidency magistrate found the accused guilty on the 2 counts and sentenced him to rigorous imprisonment for 1 year. On appeal of the High Court of Bombay held that the scope proviso to the relevant notification issued by the central government of India did not apply to a person carrying gold with him on his body. That even if it applied, the mens rea being a necessary ingredient of the offence, the respondent who brought gold into India for transit to Manila did not know that during the crucial period such a condition had been imposed, and therefore he did not commit any offence. On those findings, it held that respondent was not guilty under any of the aforesaid sections. In the result, the conviction made by the presidency magistrate was see aside. This appeal has been preferred by a special leave against the said order of the High Court. Learned Solicitor General appearing for the state of Maharashtra contends that his act was enacted to prevent a smuggling of gold in the interest of economic stability of the country, and therefore in contravening the relevant provisions of such an act there is no scope for applying the presumption of common law, that is mens rea is necessary ingredient of the offence. The object of the statute and the mandatory terms of the relevant provisions, the offence, the object of the statutes, and the mandatory terms of the relevant provisions, the argument proceeds rebut any such presumption and indicate that mens rea is not a necessary ingredient of the offence. He further contends that on a reasonable construction of the second proviso of the notification dated 8th November 1962 issued by the Board of Revenue, it should be held that the general permission for bringing gold into India is subject to conditions laid down in the second proviso, and that, as in present case, the gold was not disclosed in the manifest. The respondent contravened the terms thereof and was therefore liable to be convicted under the aforesaid section of the FERA Act, that is section 8. And no argument was advanced before us under section 168 clause 8 subclause I of C Custom Act, and therefore nothing need to be said about that section. Learned counsel for the respondent sought to sustain the acquittal of his client, practiced practically on the ground which found favor with the High Court. I shall consider in details his argument at appropriate place of the judgment. The first question turns upon the relevant provision of the Act and the notification issued thereunder. At the outset, it was be convenient to read the relevant parts of the said provisions and notifications for the answer to the question raised to depend upon them. The central government may be, by notification in the official gazette, order that, subject to such exemptions, if any, as may be contained in the notification, no person shall, except with the general or special permission of Reserve Bank of India, on payment of the fee, if any prescribed bring or send into India any gold is explanation. The bringing or sending into any port or place in India of any such article as aforesaid intended to be taken out of India without being removed from the ship or conveyance in which it is being carried shall nonetheless be deemed to be bringing, or as the case may be, sending into India of that article for the purpose of this section. In exercise of the power conferred by the said section on the central government, it had issued the following notification dated 25th August 1948 as amended up to July 31st, 1958. In exercise of the power conferred by the subsection 1 of section 8 of the Foreign Exchange Regulation Act 1947, and in supersession of the notification of the Government of India, the central government is pleased to direct that, except with the just general and special permission of Reserve Bank of India, no person shall bring or send into India from any place out of India any gold coin, gold bullion, gold seeds, or gold ingot, whether refined or not. The Reserve Bank of India issued a notification dated 25th August 1948 giving a general permission in the following terms. Reserve Bank of India is hereby pleased to give general permission to the bringing or sending of any such gold or silver by sea or air into any port in India, provided that the gold or silver given under example is on the through transit to a place which is outside both the first the territory of India and second the Portuguese territories which are adjacent or surrounded by the territory of India, and is removed from the carrying ship or aircraft except for the purpose of transshipment. On November 8, 1962, In supersession of said notification, Reserve Bank of India issued the following notification, which was published in the official gazette on November 24, 1962. The Reserve Bank of India gives general permission to the bringing or sending of any such following articles, namely any gold coin, gold bullion, gold seed, gold ingot, whether refined or not, into any port or place in the India when such articles is on through transit to a place which is outside the territory of India, provided that such article is not removed from the ship or conveyance in which it is being carried except for the purpose of transshipment. Provided further that it is declared in the manifest for transit as same bottom cargo or transshipment cargo. The combined effect of the term of the section and notification may be stated thus: no gold can be brought in or sent to India, though it is on through transit to a place which is outside India except with the general or special permission of Reserve Bank of India. Till November 24, 1962, under the general permission given by the Reserve Bank of India, such gold could be brought in or sent to India if it was not removed from the ship or aircraft except for the purpose of transshipment. But from that date, another condition was imposed thereon, namely that such gold shall be declared in the manifest transit as same bottom cargo or transshipment cargo. Pausing here, it will be useful to notice the meaning of some of the technical words used in the second provision to the notification. The object of the maintaining the transit manifest for the cargo, as explained by the High Court, is twofold, namely to keep a record of the goods delivered into the custody of the carrier for safe carriage and enable the custom authorized to check and verify the dutiable goods which arrive. Let's see the meaning of dutiable, guys. Dutiable goods, it means sulkde goods which arrive by a particular flight. Cargo is a shipload or the lading of a ship. No statutory or accepted notification of the word cargo has been placed before us. While the appellant contends that all the goods carried in a ship or plane is cargo, the respondent counsel argues that nothing is cargo unless it is included in the manifest. But what should be included and what need not to be included in the manifest is not made clear. It is said that the expression same bottom cargo and the transit cargo throw some light on the meaning of the word cargo. Article 606 of the chapter on shipping and the navigation in Halsbury's A Law of England, 3rd edition, volume 35, at page number 426, bring out the distinction between two types of cargo. If the cargo is to be carried to its destination by the same conveyance throughout the voyage or journey, it is described as same bottom cargo. On the other hand, if the cargo is to be transshipped from one conveyance to another during the course of transit, it is called transshipment cargo. This distinction also does not throw any light on the meaning of the word cargo if the expression cargo takes in all the goods carried in the plane, whether it is carried under the personal care of passenger or entrusted to the care of the officer in charge of the cargo. Both the categories of the cargo can squarely fall under the said two heads. Does the word manifest through any light? Inspector Darin Bezan Bapu says in his evidence that manifest for the transit discloses any such goods as are unaccompanied baggage but on the same flight that accompanied baggage is never manifested as cargo manifest never manifested as cargo manifest in the absence of any material or evidence to contrary. This statement must be accepted as the correct representation of the actual practice obtaining in such matters, but that practice does not prevent the imposition of a statutory obtaining in such matters, but that the practice does not prevent the imposition of the statutory obligation to include accompanied baggage also as an item in the manifest if a passenger seeks to take advantage of the general permission given thereunder. I cannot see any inherent impossibility implicit in the expression cargo compelling me exclude an accompanied baggage from the said expression. Now let me look at the second provision of the notification dated number 8 1962 under section 8 of the act, that is FERA Act. There is ban against bringing or sending into India gold. The notification lifts the ban to some extent. It says that a person can bring into any port or place in India gold when the same is on the same transit to a place which is outside the territory of India, provided that it is declared in the manifest for transit as same bottom cargo or transshipment cargo. It is therefore not an absolute permission but one conditioned by the said proviso. If the permission is sought to be availed of, the condition should be complied with. It is a condition precedent for a availing of the permission. Learned counsel of the correspondent MS George contends that the said construction of the proviso would include a person from carrying a small article of gold on his person of such article could not be declared in the manifest for transit as same bottom cargo or transshipment cargo, and that cargo not and that could not have been the intention of the Board of Revenue on the basis of the cargo, and that cannot could not have been the intention of the Board of Revenue on the basis of the argument proceeds. The second proviso should be made to apply only to such cargo to which the said proviso applied, and the general permission to bring gold into India would apply to all other gold not covered by the second proviso. This argument, if accepted, would be enable a passenger to circumvent and proviso by carrying gold on his body by diverse methods. The present case illustrates how such a construction can defeat the purpose of the Act. It is FERA Act itself. I cannot accept such a construction unless the term of the notification compel me to do so. I do not see any such impulsion. The alternative construction for which the appellant contends no doubt prevent a passenger from carrying with him a small article of gold. The learned Solicitor General relies upon certain rules permitting a passenger to bring into India on his person a small article of gold, but ex facie those rules do not appear to apply a person passing through India to foreign country. No doubt to have international goodwill The appropriate authority may be well advised to give permission for such a small article of gold or any other article for being carried by a person with him on his way through India to foreign countries, but for one reason or other, the general permission in express terms says that gold shall be declared in the manifest and do not see, nor any provision of law has been placed before us. Why gold carried on a person cannot be declared in the manifest if that person seeks to avail himself the provision. The permission, though I appreciate the inconvenience and irritation that will be caused to passengers bona fide, that is good faith, under section 52 of Indian Penal Code, passing through India or India to foreign country for honest purposes. I could not see my way to interpret the second proviso in such a way as to defeat its purpose. I therefore hold that a fair construction of the notification dated November 1962, 8 November 1962, that general permission can taken advantage of only by a person passing through India to foreign country if he declares the gold in the possession in the manifest to transit as same button cargo or transshipment cargo. Guys, I done with the first argument. I will continue by the next argument in the next video. So thank you for watching this video. Have a nice day.